Hello, ladies and gentlemen of District 31. My name is Daniel DiNardo. I'm standing for election to the House of Representatives for the state of Alaska. What I've been doing is preparing a number of discussions for broadcast off of YouTube so that you have easy access to be able to determine what I believe and how I came to believe it. Tonight, I'd like to talk about the attorneys. This is the most diabolical organization, one of the most diabolical organizations that exist on the earth today. It's called the Bar Association. The Bar Association is composed of communist comrade criminals. They have totally undermined the foundational principles of the Republic. They have brought foreign law into the American shores to dominate all of our institutions. They have brought corporations to dominate our entire life, both economic, social, and moral life. In fact, even your churches are now incorporated. And it's interesting that when you read the state statutes of any state, only attorneys can represent corporations. Even if you're a sole corporation and the owner, an exclusive owner and manager, you still have to hire an attorney if you decide to go to court. My objective is to introduce legislation immediately to unincorporate the Bar Association and to banish any concept whatsoever of attorneys. The common law got along for centuries without attorneys. It was only when attorneys gained the upper hand through a body of business practice called equity, and this happened on the continent of Europe, where they practiced still the Roman civil law, and it was brought into England under the title of equity. Equity was one of the most hotly debated subjects at the Constitutional Convention of the United States in 1789. Many of our brilliant forefathers deemed it necessary to forbid equity from existing in the United States. But as things go, equity gained a little toehold, and now it has totally outlawed the common law, and now it dominates everything. All of your civil procedures in your state and federal courts come under equity. All of your corporations fall under equity. Maritime law falls under equity. Everything you do, even property rights, even though we refer to them as rights of law, are now only equitable. And the reason they are equitable is because you don't have any money of the realm, coin of the realm, that represents the common law as grew up with civilization. It basically is also known as the law of nature and nature's God. They have totally outlawed it because they are at the present interested in billable hours. That is the most important thing that interests them, is billable hours. And what also interests them is that through equity, the Communist International has gained a foothold worldwide. Because in equity, it's the decision and opinion of attorneys that become the law. The statutory enactments, the common law, basically are manipulated out of existence. And in fact, in this country, in 1937, in Erie Railroad versus Tompkins, the common law was found not to exist at all at the federal level. And that was Erie Railroad versus Tompkins, written by the highest-ranking card-carrying Communist Party member in the United States government, Louis D. Brandeis. Our founding fathers repeatedly stated that the federal common law preceded the very existence of the states. Now, what they said is that the only common law in existence is at the state level. But that state level common law doesn't exist because under Article 1, Section 10 of the United States Constitution, that mandates that only gold and silver coin, the state shall make nothing but gold and silver coin in payment of debt. That was abolished under House Joint Resolution 192 in 1933 under Roosevelt himself and his wife, card-carrying Communist Party members. And that, you remember, started the New Deal. The total change, the total overthrow of the U.S. Constitution in favor of international, what is called the international law merchant, not law, as I pointed out repeatedly, but business practice, to bring in foreign jurisdiction into this country to overthrow the common law, to create a bonded indebtedness for every citizen of the United States, and an insurmountable, what is called national debt, that it far exceeds, it's about over 32 trillion so-called dollars, but only actually Federal Reserve notes, because Federal Reserve notes are not dollars and have never been dollars. And for that I rely on the operational fact they're not dollars, the legal history of them, and also the what I call the basically the operational facts. But even the federal courts have repeatedly stated Federal Reserve notes are not dollars. They're a promise to pay dollars in the future. And that future will never come until the overthrow, the violent physical overthrow of what we consider the United States government and the Constitution. The attorneys are totally responsible for this, and I'm going to end this little discussion now and start in, you can tune in to phase number 2 on YouTube, where I will take this subject matter to the next step so that you can continue to learn something more about my personal experiences of 26 years in the belly of the beast. Thank you.